Thanks again for joining us this Tuesday afternoon to talk about the Biden administration's new parole in place process for certain undocumented spouses and stepchildren of U.S. citizens. This is a program that just opened up for applications within the past couple of weeks, so it's still very new. I know folks have a lot of questions about it, and hopefully we can get through all of those this afternoon. Just to cover a couple of housekeeping things, this webinar is being recorded, and a link to the recording will be provided to all those who registered after we finish this afternoon. So you can expect to receive that and to be able to share that with others who may be interested in viewing the recording. And as we go, I would encourage you to ask questions using the Zoom Q&A feature. Once we get through the prepared presentation, we will have an opportunity to address those questions that you might have, and we look forward to doing that. Just to provide everyone an introduction, I'm David Spicer. I serve as the Assistant Director of Policy for the Department of Migration and Refugee Services at the U.S. Conference of Catholic Bishops, and we have the privilege to be joined by Charles Wheeler, who is a senior attorney for the Training and Technical Assistance Team at the Catholic Legal Immigration Network, one of our very close partners. And again, we're fortunate to have Charles and to be able to benefit from his expertise and all of the information he has to share with us this afternoon. So for the discussion, we'll be going through a quick introduction of the program and the response of the USCCB in particular to the program. And then I'll turn things over to Charles from there. And Charles will give us an overview of the program itself, the requirements for applying, and what the application process looks like, and then some important things to keep in mind with respect to the program. And then, as I mentioned, we'll have a little bit of time at the end of the webinar for Q&A. And so again, please do provide any questions you have through the Q&A feature of Zoom, and I'll be monitoring those as we go. So just to begin with a quick introduction to the program, it is formally known as Keeping Families Together. This is the name that the Department of Homeland Security uses for this process. For several months leading up to the process being announced by DHS in June of this year, the USCCB joined with many others, including Clinic, in calling on the administration to protect longtime undocumented residents of American communities from needless removals. And those included the spouses of U.S. citizens, those who are receiving protection through the DACA program, Dreamers, broadly speaking, and others. And so this has been relief that the USCCB and others have been supporting really throughout the Biden administration, and especially over the past year or so in a more concerted way. As I mentioned, the program was first announced in June of this year, June 18th, to be precise, and then DHS began accepting applications online for the program on August 19th, and continues to do so today. Some of you might have heard about some litigation that has been brought since then, and Charles, I believe, will be touching on that a little bit later on into the webinar. And just as sort of a note for awareness, DHS estimated when the program was first announced that 500,000 spouses and 50,000 stepchildren of U.S. citizens could be eligible. Obviously, that is a significant number of people, but when we take the total population of people who are in the United States presently and without status, that is obviously a smaller percentage of that total number. And even if we look at the total number of undocumented folks who have been here for at least a decade, that is still a much smaller percentage of even that number. So this is a fairly limited program in terms of its scope, but it is obviously still very meaningful for those 550,000 or so who could be eligible to apply for this relief. In responding to the program, the chairman of the USCCB's Committee on Migration, Mark Seitz, was very receptive to the announcement. He did acknowledge, of course, as we know with programs such as DACA, that these are not sufficient in themselves. Obviously, what we are most needing to see, and what we have been advocating for as the Catholic Church, and speaking on behalf of the U.S. bishops, is a comprehensive reform of the U.S. immigration system that includes relief and a pathway to legal status and citizenship for undocumented people who have been here for a period of time. So that is what we continue to work toward, and what we continue to think is necessary to provide that full integration of people who are already contributing in many meaningful ways to American communities. And so that's something that Bishop Seitz and his fellow bishops and the Catholic Church in the United States is going to continue to advocate for with members of Congress and with the administration going forward. But for the time being, obviously, we have this process that is available, and Charles is now going to take us into the process itself. Thanks very much again for joining, Charles. We're grateful to have you.
Great, thank you, David. And I am going to keep this relatively basic, because I know a lot of you are not going to be processing these, helping immigrants apply for this status. So we'll get into questions. We'll get a little bit deeper later on in the Q&A session. But let me start by describing what parole is. And it is a kind of a vague status. And most people think of people being paroled into the United States, which is usually how most people get that status. If you are not eligible for, let's say, a non-immigrant visa or an immigrant visa, but nevertheless you need to come into the United States for what is classified as urgent humanitarian factors, then on a case-by-case basis, the Immigration Service has the authority, and this can take place right at the border. It might take place through a U.S. consulate. You're eligible to come in for a specific period of time, and with this parole status, you're also eligible to apply for work authorization. So most people come in usually for health-related reasons, or to join a family, maybe to attend a funeral, things like that. But in fact, parole has been expanded to include people who are already in the United States. And those started out with people who came in as Cubans and wanted to and needed to apply for the Cuban Adjustment Act. So back a few generations ago, back in the 1980s, really, they started giving parole status to people who are already in the United States. And the reason this is a benefit is that not only for Cuban adjustment, you had to be inspected and admitted or paroled, but more importantly, everyone else who is otherwise eligible to get a green card, to get permanent residency, and who entered without inspection, needs to either leave the country and come back in with parole status or some other lawful status, or they need to get this parole status while they're in the United States. And why this is so important is people who are married to a U.S. citizen or who are the children, unmarried children under 21 of a U.S. citizen, if they can get this sort of golden ticket, this parole status, they don't have to be in lawful immigration status. They don't have to have entered with a tourist visa and come in lawfully. They can apply to get their green card here in the United States, coupled with the fact that they are what's classified as an immediate relative. Those are the spouses of U.S. citizens, the unmarried children of U.S. citizens, and also the parents of U.S. citizens who are at least 21 years of age. So if you have that combination of immediate relative plus inspected and admitted or paroled, you don't have to leave the United States. You can apply directly for your permanent residency here in the United States. So now turning it to the people who are now expanded to include it in this program, are the spouses and stepchildren of U.S. citizens. probably the biggest category of people who have been getting parole in place are family members where they have a child or a spouse who is in the military. And this was expanded about maybe 15 years ago. This is called parole in place for military family members. So what this new program is doing is just simply taking an existing program and taking it to another, I guess you'd say, very helpful group of people, a deserving group of people, to allow them to get their green card here, other than having to leave the United States. And when I say having to leave the United States, that means going through consular processing. In other words, leaving, going to a U.S. consulate abroad, applying for an immigrant visa, and coming back into the U.S. Ideally, that would take 2 or 3 days. But what stops people is that if they entered without inspection, then they're going to accrue what's called unlawful presence, and then they're going to be prevented from coming back to the United States, usually for 10-year periods, some for only 3 years, but most people for 10 years. Now, you can apply for a waiver for that bar before you leave the United States, but you have to establish extreme hardship, let's say, to this U.S. citizen spouse, which isn't impossible to get. In fact, a lot of people get it. But there's now a 3 to 4 year wait in getting that waiver granted. So what this does is simply eliminate the need to apply for this waiver, stay in the United States, hoping that this waiver will be granted, and then in 3 or 4 years leaving the United States. This just simply means they can apply directly once this parole status is granted. All right, so that's what it is in general. It's found in the statute. In a section 212D5 of the Immigration and Nationality Act. Unlike DACA, which is basically a temporary holding pattern for people who qualify for that, children who entered at a certain age and have been here for a certain period of time, DACA is something called deferred action, which is not in the statute. It's something that was created by the Immigration Service, sort of a last gasp to keep people here, again, for humanitarian reasons. And when the president created this whole program to allow dreamers to get this status, some people think he crossed a line and only Congress can do that. That's much weaker argument when applied to parole status, since parole is embedded in the statute and presidents have been using that executive authority for generations to allow people to stay here. All right, is it likely to be challenged and enjoined? Boy, well, we know the answer to that one. And we were expecting this classic red states to join together to try to stop this process. Why? They don't like anything that benefits immigrants, whether it's also benefits their states or not, that's irrelevant. They're trying to embarrass the Biden administration. They're trying to make as much chaos as they can at the border, and they don't want to see any success using executive authority to make things better for everybody. All right, so that's kind of a cynical way of looking at it, but it's a bit of a stretch to say that the states have any standing to sue and are likely to experience any economic loss. If anything, it's the opposite. So anyway, we're going to see what happens. They did file a lawsuit on Thursday of last week, and on Monday, yesterday, a very conservative Trump-appointed judge in the Eastern District of Texas, where all these cases are filed, issued what's called an administrative stay, which looks a lot like a restraining order, an injunction, but it's not quite the same. It means that the judge hasn't really made any decision as to who is likely to prevail, but is simply saying, there's enough here for me to hold things off for a while until we can take a better look and sort out the rights and benefits and the losses and the arguments, and to see whether any of these have any weight. So for a 14-day period, the administration can't adjudicate these applications, but people can still continue to file. We're encouraging people to file and get in line. Those people who have already been granted, and there are a number of them, in fact, since this application started on Monday of last week, A lot of people, in fact, have already been granted parole status, and that won't be affected by this lawsuit. All right, so let's take a look at the basic eligibility for spouses and of these U.S. citizens. You see up there basic bullet points. You have to have entered without inspection. And what does that mean? You have to have crossed between ports of entry. You have to have crossed the river, so to speak, gotten a coyote to help you across. You might have rushed right up to a Border Patrol official after you'd crossed, but you entered without inspection. You didn't go through a formal port of entry and being allowed in at that point. You can't have entered with a tourist visa and overstayed, things like that, or a border crossing card or anything like that. All right, you have to have been married to a U.S. citizen on or before June 17th, 2024. That's when this program was announced. They didn't want people coming in response to this announcement. So they cut it off at that point. And you had to have been here continuously, physically present since June 17th, 2014. In other words, for 10 years. No disqualifying criminal activity. I'll talk about what that means. Not a threat to national security. That's pretty rare, but again, that's one of the things they have to state as well. And then positive discretionary factors, which I'll also describe. So that's the basic eligibility for spouses of U.S. citizens. And it looks a lot similar to eligibility for the stepchildren of U.S. citizens. Again, you had to have entered without inspection, continuous physical presence, though, only since June 17th, 2024. You don't have to have been in the United States for 10 years. You have to have this stepchild relationship, which I'll define here in a minute. Again, on or before that June 17th, 2024 date, you had to be under 21 on June 17th, 2024. But you're looking at something called your Child Status Protection Act age, which is not the same as your biological age. And bear with me while I describe what that means. If you are a stepchild of a U.S. citizen and your stepfather or mother files a petition, in other words, starts the process for you getting your immigrant visa or your green card, then your age is frozen as of the date that petition is filed. So even if you were over 21 on June 17th, 2024, we're looking at your adjusted age, which means that being an immediate relative and being under 21 on the date the petition is filed means that you are always immediate relative. You will never turn 21 in the eyes of the Immigration Service as long as you stay unmarried. So that's what we mean by under 21 on June 17th, using your biological age or your Child Status Protection Act age, your frozen age. All right, and again, no disqualifying criminal behavior, no threat to national security, and then we're going to look at these positive discretionary factors. All right, so let's look a little deeper here at the spouses of U.S. citizens and see what they have to establish. We might think of marriage to a U.S. citizen. Well, everyone knows what that is. But there are certain things to keep in mind. The definition of marriage turns really on how that is defined, where the marriage took place. Most of these marriages will take place in the United States or one of the U.S. territories. But if not, you're going to look at the jurisdiction where it did take place. And if it was valid and bona fide at that time, then that's what we're going to go with. There are certain things that violate public policy. Polygamous marriages, for example, proxy marriages when the parties were not actually physically together when the marriage took place. Those violate public policy. Common law marriages, about 10 or 11 states in the District of Columbia say that if you reside with someone in that state, you hold yourself out as married, and everyone seems to assume that you're married, then that qualifies as common law married. And USCIS will accept that, but they are going to want some proof that, in fact, you have held yourself out and you comply with whatever state laws govern common law marriage. Widows, again, as long as this marriage took place on or before June 17th, 2024, the U.S. citizen spouse could have died. In that case, you are a widow and you're still eligible to proceed as a widow. There's special protections for widows and widowers of U.S. citizens to nevertheless continue the process and get their green card. So those people would still qualify for parole in place if they, for whatever reason, entered the United States without inspection and otherwise had to leave. They can still qualify for this parole status and not have to leave. All right, so that's sort of an overview. You don't have to establish that it was a happy marriage, that it was still living together even, as long as it was bona fide at the time it occurred and as long as it hasn't been terminated before June 17th, 2024. So there's all sorts of documents you're going to need to gather and include. I'm not going to go into the details of all those, but those of you who are helping people will want to pay attention to what those look like and what examples you have to establish. Not only that the U.S. citizen spouse is a U.S. citizen, but that in fact the marriage took place. All right, let's look at definition of a stepchild. That means that you were under 18 when your parent, your biological parent, married this other person. This other person in this case happened to be a U.S. citizen. So as long as that marriage took place on or before June 17, 2024, and as long as you were under 18 when that marriage took place, you are by definition a stepchild. You might be over 18 now, as long as you're under 21. Again, remember that when this parole in place application is filed, you're okay. This program is not open to the biological children of U.S. citizens. Isn't that kind of bizarre? It's only the stepchildren. So you're really looking at your relationship, your blood relationship to the parent who is also from another country and is also probably seeking this parole in place status. The child can apply on their own. They don't have to be applying at the same time, or even maybe the parent doesn't qualify. But if the child does qualify, then they can apply separately. And we don't have to worry about being born in or out of wedlock. That's irrelevant for being a stepchild. It even includes adopted parents of this parent who is coming into the United States from another country. And then again, as I mentioned, the widows of U.S. citizens qualify. That applies also for the stepchildren if the marriage has been terminated based on death of the step parent or the biological parent. Nevertheless, that stepchild can continue to qualify as a stepchild if they maintain a relationship or had a relationship with this step parent. All right, let's look at some of the other things. As I mentioned, documenting the continuous residency and documenting the marriage and documenting the discretionary, positive discretionary factors are going to be an important thing. And those of you who are actually assisting people with this will get very experienced in how to upload these documents onto the form. These are just some of the documents that are recommended for establishing continuous residency. You can use whatever ones you think might work, but those are the ones that are probably the most effective, particularly school records and health records and tax records, all of that stuff. You don't have to establish every day of every year, but something indicating the 10-year period. Be reasonable in terms of what quantity of documents you want to submit. But I would say tax records are great as well as any declarations from people who can attest to your being here. All right, so that's documenting continuous residency. Let's go a little deeper. I mentioned that there were certain disqualifications for criminal behavior. And that's important to know. And let me back up and explain that the general grounds of inadmissibility that apply to everyone who is trying to get a green card do not apply for purposes of just getting this parole status. In other words, the Immigration Service isn't going to be looking at anything other than what the results of your fingerprint checks and other biographical information that's going to come up. So they're going to be looking at basically the same thing the FBI has on you. If you've ever been fingerprinted in relation to interactions with police, with criminal enforcement, with immigration enforcement, that's going to be triggered, and that's going to be coming up. You're going to have to explain it. If it was a criminal matter, then there are certain disqualifying convictions, and you see them all up there. They're fairly serious. Any felony, regardless of what it was, and then pretty much any controlled substance. You get into other issues dealing with aggravated assault, firearms, and things like that. So if you have anyone who does have a serious conviction, then that's going to be disqualifying. You don't get into the lesser ones. Certain traffic offenses obviously don't count. Even DUIs are not going to keep you out driving under the influence. That you may remember is a disqualifying one for DACA, but it doesn't apply here. So again, these are going to pop up on your fingerprint rap sheet. What they do is require you to appear for biometrics. Those are digital fingerprint checks, and then they run that, come up with anything that indicates you might have a criminal record. Other things, let's talk for a minute about public threat to public safety, terrorism, things of that nature. That might also appear in any kind of FBI record, but how this is screened out for inadmissibility relies on answers to specific questions on the forms. And there's only one question on this form, which basically says, are you a threat to national security? And I assume most people would say no. So they're not doing a deep dive other than what, again, pops up on your fingerprint checks. So again, if you have somebody who has criminal issues, you might want to look at the list and see whether that's going to be a major problem for them or not. All right, let's look at this issue called discretion. And this is the other big one, where you're going to want to come up with some sort of positive equity, some sort of documentation that establishes that you're a parent of a child, or you're helping another family member. Perhaps you're a caregiver for a parent or someone who's aging. Any kind of positive factors, payment of taxes, steady employment, clean record on criminal issues. Maybe you do some community service, maybe you're a member of the church, and making sure you address any negative factors. If you do have a DUI, for example, you're going to want to describe that, talk about remorse, rehabilitation, all that stuff. Certain other factors will be considered positive as well: health, age, disability, things of that nature. All the things that you would think of that would establish hardship should be thrown in, hardship to you or hardship to your family members, although it's, again, not the same kind of factor as extreme hardship when you're trying to get a waiver. Most people, I would assume, will be able to come up with some documentation establishing positive discretionary factors, which is really all that they're looking for. All right. The last thing I really want to talk about is the application process itself. It is a special form. It's, see up there, it's a form I-131F. The I-131 is an application for a travel document or for advanced parole. So this just is a different kind of travel authorization parole status application. And it's all filed online. It has a $580 fee. There's no fee waiver. By filing it, you will get an appointment. Come have your fingerprints taken, probably within 2 or 3 weeks. And then part of this form, as I mentioned, includes uploading the various documents that establish, first of all, your identity, then the marriage issue, and then the issues dealing with continuous residency, and then the positive discretionary factors. All right, so let me just sort of finish this by saying, if you are one of the people who gets this parole status, what are the next steps? That entitles you to proceed to getting what's called adjustment of status. This means that you're applying here in the United States. Why? Because you are now married to a U.S. citizen. You start the process with a petition. It's called an I-130 petition that establishes your relationship to this U.S. citizen, whether it's as a spouse or a stepchild. And then you submit another application called the application for adjustment of status, along with that parole approval. So remember, being an immediate relative and being paroled in is all that's necessary to apply for adjustment of status with this approved I-130 petition, or even a pending I-130 petition that establishes this relationship. You can apply for a work permit as well once you get parole status, but that's only a 3-year work permit. It also costs $560 or $520, I forget. I recommend that you apply for a work permit once you apply for adjustment of status. Why? It's a 5-year work permit, and it's cheaper. It's only $260. So most people would probably do that. And then finally, once you apply for adjustment of status, you probably included evidence of a bona fide relationship to a U.S. citizen. And if that's true, you may not even have an adjustment interview. The Immigration Service is trying to work through a backlog and not schedule everybody for a interview. But otherwise, if you are interviewed, then you would simply attend that with your spouse or your step parent and hopefully be granted permanent residency. But that second stage is where all these grounds of inadmissibility would apply. The issue dealing with the fact that you've been here without status is not an issue because you haven't left and triggered a bar. But people who have left during that 10-year period, or maybe even came in and waited and was here for a while and left before that 10-year period, they would trigger something we call the permanent bar. It sounds terrible, and it is fairly severe, which means that you can only get your green card after you have left the United States, waited abroad for 10 years, and then filed a separate waiver. And this parole status doesn't help those people. So while you can get parole status and get this 3-year work permit, you won't be able to apply for adjustment of status. And that's one of the big things that a lot of people were concerned about as to whether, in fact, they should be encouraging clients to apply for parole when, in fact, they know that they won't be eligible to get their permanent residency here in the U.S. They could have made a false claim of citizenship. They could have done other things that may take them out of possibility. They could have committed fraud, misrepresentation, again, requiring a separate waiver. There's all sorts of reasons why someone might be allowed to get parole, but not a green card. And one of the important things that we have learned is that, yes, a lot of people, and David cited this 500,000 people might be eligible. That's, I think, a lot more than will, in fact, apply, assuming this case gets settled and people get the green light to be adjudicated. I think it's much, much fewer. And I think a lot of people are not going to qualify for adjustment, but will, in fact, apply and be only granted this parole status. And that after that, it really depends on what their immigration issues are and whether they can overcome them somehow. All right, what are the risks? Well, under this current administration, the enforcement priorities indicate that only people with serious criminal matters, only people who are threats to national security, or people who have entered recently, in other words, in the last 4 years, are what's considered an enforcement priority and could be put into proceedings, immigration proceedings before an immigration judge. Otherwise, they are not a risk. That would change if Trump is reelected. His enforcement priorities were as follows. Everybody is an enforcement priority. So if that's true, then coming forward and applying for this parole status could be used against you, right? We don't really know how that would shake out until Trump would come in and do something, terminate the program, and maybe use it as a way to go after people. So you are concerned about that. Obviously, the thing to do is to wait for the results of the election. All right, why don't we stop there and open it up to questions? I see there's at least 3 questions already posted. So David, why don't you take us through and I'm ready to go.
Awesome. Thank you so much, Charles, for all that great information. I know for the folks listening, it is probably a lot to take in, but that is sort of the nature of immigration law, and this process is no exception. So jumping into the questions, and for those that may have questions who have not asked them yet, I encourage you to put those in through the Zoom Q&A feature, and we will get to those shortly. The first question, Charles, is whether or not marriages celebrated abroad fulfill the requirement for this process.
And the answer is yes. As long as that marriage is considered valid and complies with the civil requirements in that country, then it's accepted here in the United States. And that's true for this parole status. It's also true for being able to immigrate based on this relationship to a U.S. citizen or lawful permanent resident spouse. There is something called the State Department Foreign Affairs Manual, and there's a section in that lists every country in the world and the documentation that is considered necessary to have that certificate of marriage be considered official. So if you have any doubts as to whether the documentation would meet the requirements, you can go to that website. It's called the Reciprocity Table of the Foreign Affairs Manual. Just cursor down to the particular country where the marriage took place, and it will tell you what that government considers valid documentation based on marriage, divorce, birth, adoption, whatever it is.
Great, thank you. And then the next question we have is whether or not a concurrently filed I-130 is necessary for adjusting status. And I assume they mean concurrently filed with the I-131F, although I don't know for sure.
Okay, so the I-131F has to be filed separately. It cannot be combined with anything else. What David's referring to is this I-130 petition, which only establishes relationship. Let's say I'm married to a U.S. citizen. That U.S. citizen's spouse can start the process anytime. Doesn't have to wait for the I-131, doesn't have to wait for the adjustment of status. All it does is establish relationship. And again, that can be done as soon as the couple gets married. What the parole and status allows is really the next step. It's the adjustment of status stage. So once you have an I-130 that's on file, whether it's pending or approved, that's basically the first step. You can combine the first step with the second step, which is filing for adjustment of status. And notice that I started off with a petition filed by a U.S. citizen petitioner. That's the I-130. And then you switch to an adjustment application filed by the person who is trying to get the green card. And some people can combine those. They can file an I-130 along with this adjustment right at the same time concurrently if they entered with inspection. But they couldn't file the I-130 and the 485 if they entered without inspection. They would have to wait for the approval of the I-131F application. In other words, once they get parole status, they can then complete the second step, file for adjustment along with the approval, or they could file all three together. They could then file the I-130, the adjustment, and the parole status all at the same time.
Thanks, Charles. And I think there was a follow-up from the same person related to the I-864, whether or not that would need to be filed concurrently as well.
So the I-864 refers to something called an affidavit of support. And that has to be filed with everyone at this second stage, at the adjustment of status stage. So yes, when you file the application for adjustment of status, that's when you'd file the affidavit of support. Every petitioner, remember that person who's a U.S. citizen who starts the process, becomes a sponsor at the second stage. So this petitioner becomes a sponsor and completes this affidavit of support that says, I, the sponsor, I, the petitioner as well, have enough money to be able to sponsor this wife, this husband, this child, and here's how much money I have, and that's enough. So that's what the affidavit of support says.
Great. The next question has to do with the timing of the common law marriage being recognized, whether or not that needs to occur. I think what the person meant is before the process was announced, or whether or not the common law marriage can have been recognized since then.
Well, as I indicated, about 10 states have common law marriages. Each of those 10 states has different regulations and factors and eligibility considerations in terms of who is common law married, what you need to do to establish that. If I was in one of those states and I was in a common law marriage relationship with someone, in order to get my green card, I would need to have to go down to the civil authorities and I would have to register this common law marriage. The thing is that in most states, you can backdate it. Let's say today is August 27th, 2024. We could go down together, we could fill out the form, and we could put the date that we entered into the common law marriage as whatever, August 27th, 2020, or whatever it was, right? So you can backdate it. So that's a good thing. But yes, the short answer is the common law marriage would have to have been entered, not necessarily officially on the books, if not backdated, on or before June 27th, June 17th, 2024. But again, you have to look to the rules in your state. The thing with the parole in place is you don't have to get that official registration. You just simply have to submit additional documentations to the USCIS for this parole program that indicate that you did comply with the common law marriage requirements. You don't actually have to go down and get an official registration like you did at the second stage, at the I-130 stage. So I'm sure that's overly complicated, but again, this doesn't apply to too many people.
No, that's appreciated, Charles. Common law marriage is a tricky thing, even as somebody who went through law school. There's another question here. I'm having a little bit of trouble with the wording of the question, but I think the person asking the question is referring to somebody outside of the United States, and I think probably the best response there is that the program is only available to those who are currently physically present in the country, right?
That's correct.
Anything you would add? Okay.
That's what we mean by parole in place, as opposed to parole, which you would apply for outside the United States. If you apply based on humanitarian factors and are able to get paroled into the United States, and that process starts with another form, it's called an I-131 form, then of course you would have that status and you could continue. But this program is only for people who are here in the United States.
Great. The next question is a clarification. If somebody qualifies for adjustment of status, they do not qualify for this new program? That's what's being asked.
Well, if they qualify for adjustment of status because they entered with inspection, in other words, were inspected and admitted or paroled, then they don't need to get parole in place, right? They can just file directly under this statutory provision called Section 245A of the Immigration Nationality Act. If you're immediate relative, in other words, if you're married to a US citizen, none of the other prohibitions, let's say you can't have overstayed your visa, you can't have worked without authorization, you can't have violated the terms, none of those apply to you. So that's good. That's why if you're not an immediate relative, this program doesn't qualify, you don't qualify for it, and that gets a little complicated. Let's say you're married to a permanent resident, somebody who has their green card, then there are all sorts of prohibitions on your being able to get your green card here in the US, but those prohibitions don't apply to people who are married to US citizens. So that's why this program is really only geared for immediate relatives, spouses or children of US citizens.
And then another question has to do with the ongoing litigation. Charles, whether or not the Texas judge has the authority to end the program permanently.
That's a great question. What happens is these cases are brought with a number of states. I can't count them, but it's usually about 13 states up to 26 states. In this case, it was a shorter list. But if there is sort of a balance of states that convince the judge that this program should be ended, what typically happens is that the judge says, okay, I'm going to declare and grant a restraining order. Again, this hasn't granted a restraining order, it's only stayed it temporarily. But if the judge were to say, all right, the balance of the equities flows in favor of the states that have brought this litigation, as opposed to the government, then that would pretty much end it for everybody, because it would just be too cumbersome and too complicated to have a program that works in 30 states, but not the other 20, right? So that happened, for example, with DACA. It's happened in a number of other cases where they don't apply for what's called a class action, but it's treated as a nationwide injunction as well. But what happens is this would then be appealed immediately to the Court of Appeals in what's called the Fifth Circuit, and the government would ask for a stay. If the court has already granted an injunction and has stopped the program, it's unlikely that the judge would stay that injunction, would stop that injunction, particularly since the judge has already been eager to stop the program already. It goes to the Fifth Circuit. It sits there for about 6 to 8, 9 months, and then Fifth Circuit would almost surely agree with this very conservative judge in East Texas. Why? Because Fifth Circuit is the most conservative circuit in the country. Much more conservative. I use the term conservative. I'm not sure, there's probably a better word. Anyway, much more conservative than the US Supreme Court. You can believe that. And we've seen cases where the Fifth Circuit has agreed to stop programs that even the Supreme Court says, wait a second, now you're really going too far. And for example, we saw that with the Biden's enforcement priorities. Remember these enforcement priorities that said only that certain categories of people are subject to deportation or enforcement? The Texas and a few other states sued to stop that change in enforcement from the Trump to the Biden enforcement. The Fifth Circuit said, we don't have any problem stopping that. Do whatever you want. If it's bad for immigrants, we like it, essentially. That went up to the Supreme Court and said, whoa, we don't like immigrants either, but this is really taking it too far. And the president does have the authority to use his or her own enforcement priorities. I think they were worried that when Trump got back in, if they agreed with Fifth Circuit, that would somehow limit what the next president could do. Anyway, to give you a further analogy, the Biden administration enacted by executive order a major parole program for Cubans, Haitians, Nicaraguans, and Venezuelans. And 30,000 of them each month have been able to enter the United States with this parole status based on humanitarian factors. And again, they apply for this, they come in. There's been over 500,000 that have come in so far. Texas and a few other states didn't like that either. They sued to enjoin it. The Texas judge, unfortunately for them, was actually a Biden Democrat appointee who said, wait a second, after a long trial, I still don't think you have any problem here. This is actually a win-win for everybody. So that lawsuit failed. And it'd be surprising that if that lawsuit had been filed, obviously in front of that judge, we wouldn't be seeing the stay. So it all really depends on who the judge is, what their policies are, how much they hate immigrants, essentially. All right. Are we done?
Thanks for that analysis, Charles. One follow-up question relating to whether or not for the fee associated with the application, obviously there's no fee waiver available for this process, but if somebody were to apply during this time when no adjudications can occur, can they expect to have the fee refunded if it is the case that the program gets enjoined going forward?
Well, if it is terminated, that's a great question. Unfortunately, I don't know the answer. It's rare that you get your application fee returned to you. But this may be one of those rare situations where if you can still file and yet it's enjoined, I would think you'd have a very good argument as to why, if the USCIS has not accepted the fee, has not adjudicated it, it's all just sitting there. Maybe this is one of those rare opportunities where you would be entitled to get your fee back. I just can't answer that. Sorry.
Got it. No, it's okay. I appreciate that. And then the final question we have here, it looks like, is for widows, does the 2-year filing requirement still apply?
All right. So let's take a look. Two issues here. If you are a widow or widower, and by definition, that means you were married to a U.S. citizen, that U.S. citizen died, and you took action within 2 years of that death, then you can basically file your own petition. It's called a self-petition, and proceed as if that U.S. citizen spouse had not died. But again, you have to take some action within 2 years. If the U.S. citizen had started the process already by filing an I-130 petition, then that petition automatically converts to this self-petition for a widow or widower. I would presume that if you didn't take any action within 2 years of your spouse dying, then you would lose the ability to take the next step and apply for adjustment of status. So I would assume that for purposes of parole in place, they're not going to consider you a widow if the death took place more than 2 years ago and you failed to take any action.
Great. Thank you so much, Charles. Appreciate all of your time and your willingness to entertain all of those questions. Thank you to everyone who submitted questions and for joining us this afternoon for this really informative conversation with Charles. As you can see there on the screen, we have a few different links. We have the website for the USCIS page for this Keeping Families Together process. Not only do you have the link to the application on that page, but you also have information from USCIS about the eligibility requirements and frequently asked questions and other resources from the agency itself that you are able to refer to. We also have the website for the Department of Migration and Refugee Services of the USCCB. So I'd encourage you all to check that out if you would like to learn more about the work of MRS and how to connect with us. And then justiceforimmigrants.org is the website for the Justice for Immigrants campaign of the USCCB, which was established in 2004 initially for the primary goal of securing immigration reform. That remains a primary goal of the coalition, but of course it is also broadened to include other issues such as the one that we addressed today. And then the last thing is just that there on the screen you have a link that you can go to be able to sign up for updates from the USCCB's Justice for Immigrants campaign to keep up to date about the work of the U.S. Catholic Church in this area and to be able to engage on advocacy and other opportunities as they arise. So thanks so much, everyone, again, for joining us. Big thanks to you, Charles, for all of your knowledge and great work that you do over at Clinic, and hope everyone has a blessed rest of the day.